Hello, everybody. Welcome in. We'll get started in just a few more seconds. Give everyone a chance to get on Zoom first. Thank you all so much for being here, joining us today. It's great to see everyone online. All right, let's get right to it. Hello, everyone. Thank you for joining us and welcome to the latest session of Summer School from the Environmental Law Institute, all about the basics of the Clean Water Act. My name is Sarah Viken. I'm the manager of educational programs here at ELI, and we have a fantastic one lined up for you today. We'll be hearing from a few experts on the Clean Water Act, and I want to take a moment to thank our speakers, Dave, Carol, and Julia, for being here with us today to close out our first month of summer school. As you can see, we are taking next week off and returning on July 9th with our energy law and the energy transition session, but this marks the last session of those major environmental statutes. So thanks for everyone for tuning in. Following presentations from Dave, Carol, and Julia, we'll be taking audience questions. So please submit any questions that you have throughout the program using Zoom's Q&A function. I believe we'll be taking a break in the middle and at the end. So whenever you think of those questions, please drop them in that Q&A. We encourage you to use the chat for observations, comments, and questions, but for those discussion questions, we will be pulling them from the Q&A box, so make sure you also drop them in there as well. Today's webinar will be recorded and it will be posted on the event webpage within a few business days. You can find the recording and register for future sessions of summer school at eli.org. I'll put the link in the chat momentarily. Now, before we get started, I want to introduce our wonderful moderator. Guiding us through the next couple of hours will be Dave Owen. Dave is the Associate Dean for Research and Harry Sunderland 61 Professor of Law at the University of California College of the Law in San Francisco, where he teaches courses in environmental, water, land use, energy, and administrative law. A graduate of Berkeley Law, Dave clerked at Federal District Court and worked for a small law firm in San Francisco, where his practice focused primarily on water law. He worked on Colorado River allocation, Sacramento-San Joaquin Delta litigation, and federal state disputes over the proposed Yucca Mountain Nuclear Waste Repository, among other matters. Since entering academia in 2007, Dave's research focuses primarily on water resource management, and some of his recent projects have addressed rules of negotiation and environmental regulation, equity implications of a turn towards community-centered energy governance, groundwater surface water interactions, taxation of water consumption, the roles of federal regional offices, stream protection under the Clean Water Act, and policies to expedite dam removals and hydropower upgrades. 5 of his articles have been recognized by his peers as among the top environmental law articles of their respective years. Another article has won the Morrison Prize as the top sustainability law article of its year, and he's presented 3 articles at the Harvard, Stanford, Yale Junior Faculty Forum. He also contributes to the Environmental Law Prof blog. Thank you, Dave, for sharing your time and expertise with us today. And with that, I'll turn it over to you to get us started.
Okay, thank you, Sarah. So I'm going to start out by giving a very quick overview of how this morning is going to work, and then I will turn it over to our speakers. Next slide, please. So initially, here are the 2 main speakers you're going to be hearing from today, and I'm going to give each an introduction. So Carol Courtenay is a staff attorney at the Southern Environmental Law Center and at their Virginia office. And SELC is the largest nonprofit, nonpartisan legal advocacy organization rooted in and focused on the South. At SELC, Carol works on land use and transportation issues in Virginia, with a focus on transforming transportation and land development practices to promote healthier, more resilient, and more equitable communities. That work often intersects with water issues, which is why she's with us today. And she also leads SELC's work on industrial chemical water pollution in Virginia. She joined SELC in 2018 after earning her BA from the University of Richmond and her JD from the University of Virginia School of Law. Our second speaker, Julia Anastasio, is the Executive Director and General Counsel of the Association of Clean Water Administrators based in Washington, D.C. Julia joined ACWA in May 2014 as Executive Director and General Counsel. And ACWA is an independent, nonpartisan national organization of state and interstate water program managers. So she works with the people who actually implement the Clean Water Act on a daily basis. At ACWA, Ms. Anastasio focuses on working with state water program directors and with EPA's Office of Water on ensuring that states have the flexibility and the resources they need to implement the Clean Water Act in their home states. She has over 2 decades of experience in government, administrative, and environmental law and policy development. Julia began her career with the Pennsylvania Department of Environmental Protection as an executive policy specialist, returned to Washington, D.C. in 2005 to work for the American Public Works Association, where she focused on environmental sustainability and infrastructure development at local, state, and federal levels. She earned her BA from Franklin Marshall College, her master's in environmental law and policy from Vermont Law School, and her JD from American University. Next slide, please. So I'm now going to give you a very brief overview of what we're going to cover today, and then also a few words about what we are not going to address in this webinar. So next slide, please. First, we're going to start with the basic elements of the Clean Water Act. Carol's going to take the lead in that part of the discussion. I will also chime in at a few specific points. Next slide, please. We will also talk about federal and state roles in implementing the Clean Water Act and protecting water quality. This will come up during Carol and my portion of the talk, but it's going to be the central focus of Julia's portion. And then next slide. Throughout, we're also going to be talking about recent developments and current areas of controversy, including cases like Sackett and County of Maui versus Hawaii Wildlife Fund. And again, that will come up throughout the talk, but it's going to be a central focus of Julia's portion of the discussion. Next slide, please. There's a couple of subjects that you might, especially if you're new to water law, might expect to hear covered in a Clean Water Act session, but we're actually not going to spend much time talking about. So the first is laws governing allocation of water rights. In other words, who has the right to take water out of waterways and put it to some sort of use. That's not really addressed by the Clean Water Act. There are limited exceptions. There are some circumstances in which state water quality standards affect water rights allocation. But for the most part, lawyers cabin off water rights to separate classes in what we call water law, which doesn't include the Clean Water Act as much. And so that is not going to be a primary focus of today's discussion. Next slide. We also are not going to talk a whole lot about groundwater. The Clean Water Act is a surface water statute, and we use other laws like hazardous waste site cleanup laws primarily to protect groundwater. There is an exception to that, and it will come up in Julia's talk when she talks about County of Maui versus Hawaii Wildlife Fund, which is a case about pollutants that move through groundwater and into surface water. But other than that, this seminar is not really going to be groundwater focused. And then next slide, please. And then one other subject that we are not going to discuss in depth today is the Safe Drinking Water Act. So the Clean Water Act you can think about as the law that governs pollutants that we put into the environment. And the Safe Drinking Water Act, its focus is on the quality of water that comes out of our taps or that comes out of public drinking water systems that send water to our taps. That's a little bit of an oversimplified distinction, but it's generally how things work. And because our focus today is the Clean Water Act, the Safe Drinking Water Act, and drinking water quality is only going to be a focus to the extent that the quality of water out there in the environment matters to drinking water. And it does matter a great deal, but we're leaving the Safe Drinking Water Act out of the discussion. All right, that's the quick overview. The way the run of the show is going to work is that Carol's going to start out. Once Carol's piece is done, we're going to take about 10 or 15 minutes for audience Q&A focused on the portion of the talk that we've just been through. Then I'll hand the mic over to Julia. And then after that, we'll have a second Q&A session. And in that second session, you can ask questions about any portion of the talk. All right, so Carol, the floor is yours.
Thanks, Dave. Hey, everyone. As Dave said, my name's Carol Courtenay. I'm from the Southern Environmental Law Center in our Virginia office, which is in Charlottesville. SCLC works in 6 different states in the Southeast. So we're in Virginia, North Carolina, South Carolina, Georgia, Alabama, and Tennessee. Our work spans many different environmental issues facing the region. And as part of this, we advocate for strong federal and state clean water protections that are consistent with the goals of the Clean Water Act. So first, as Dave said, we're going to walk through some of the basic building blocks of the Clean Water Act before passing it over to Julia. We'll first start with a short section on the background and purpose of the Clean Water Act before moving into the mechanics with definitions, some permitting sections, water quality standards, and finally a couple of the enforcement provisions. One of the reasons I really love working on the Clean Water Act issues is because of the importance of our waters to so many different people and places. Our waters, including wetlands, rivers, and streams, not only provide important recreational and economic opportunities, but they provide important environmental services. So first, let's take wetlands. Wetlands act as natural filters for improving water quality. They're natural sponges that help absorb floodwaters and lessen and slow down flooding. They protect our coasts from erosions, and also wetlands within and downstream of urban areas counteract surface water runoff and sedimentation. They also are like biological supermarkets. They provide food that attract many species and provide habitat for birds, fish, and other animals. Wetland marshes also help recharge groundwater supplies, and they store carbon within their plants and soils instead of releasing it to the atmosphere. Rivers and streams also provide many benefits. Like wetlands, they protect against floods, filter pollutants, and provide food and habitat for fish and other animals. They're also critical to maintaining the quality and supply of our drinking water. They transport water, sediments, organic matter, nutrients, organisms, and pollution to downstream water. So first, we're going to talk a little bit about the history of the Clean Water Act. Before Congress enacted the Clean Water Act in 1972, federal regulation of the nation's water generally began with the River and Harbors Appropriation Act of 1899. The main focus of this statute was, and remains today, the protection of the nation's waters for navigability. In 1948, Congress passed the Federal Water Pollution Control Act, but at this point, the law focused on pollution abatement if it was economically feasible. Now Dave is gonna give a little more context and color here about what pre-1970s water law looked like.
Okay, so during the pre-1970s period, water quality law was primarily left to the states, and the federal laws that existed. A lot of the focus was on supporting state efforts rather than direct regulation. And those laws had a couple of results. So next slide, please, Carol. So on the positive side, those laws did lead to the development of some regulatory programs, and the laws, along with advances in technology, led to treatment systems. And so the quality of drinking water in American cities over the course of the 20th century improved. And in places, there were also improvements in water quality. But, and next slide. And next slide again, thanks. It wasn't nearly enough. And in the late 1960s, here's a quote from an article by a law professor at Alabama University, named Bill Andreen. In the late 1960s, these appalling conditions afflicted countless streams and lakes across the country. For more and more Americans, water pollution was becoming intolerable. And that was because you had just massive amounts of industrial pollution and also massive amounts of wastewater treatment plant or just direct sewage discharges going straight into rivers, lakes, bays, oceans. And so the pollution was intense and it was horrible, and it created a huge amount of political pressure for improvements in water quality through a more robust legal regime.
Yeah, and we can see that with the Cuyahoga River fire in 1969. Unfortunately, this was not the first time this river had caught fire, but this time images of the flames were published in Time magazine. This and the conditions that Dave talked about had really galvanized the public's concerns for the health of our national waters and spurred a number of environmental actions at the federal level. including the passage of what we now refer to as the Clean Water Act. So between 1948 and the passage of these 1972 amendments, there were, as Dave said, various pieces of legislation that created different regulations and requirements related to water quality and enforcement. The Clean Water Act restructured and consolidated this authority. As set out in the statute, the objective of the Clean Water Act is extremely broad. It's to restore and maintain the chemical, physical, and biological integrity of our nation's waters. The statute also set out a number of goals, including the goal to completely stop the discharge of pollutants to navigable waters by 1985, and as an interim goal, that water quality be safe enough for people to fish and swim. Now, we have not met these goals, but they really illustrate the ambitious nature of the Clean Water Act and are something we should keep in mind as we go through today's panel. First up, we have Section 301 of the Clean Water Act. This provision sets out the main requirements of the Act, but it's also in tension with the no discharge goal we just talked about. It basically says that unless it's authorized by a specific provision of the law, a discharge of a pollutant is unlawful. The other specific provisions that are being referred to cover things like effluent limits, new standards of performance, toxics and pretreatment standards, aquaculture requirements, and the two provisions we'll be talking more about later, point source discharges and the discharge of dredge and fill material. But first, what exactly is a pollutant? It can be sewage, it can be industrial waste, and it can be a whole host of other things. So dredged spoil, solid waste, incinerator residue, sewage, garbage, sewage sludge, munitions, chemical waste, biological materials, radioactive materials, heat, wrecked or discarded equipment, rock, sand, cellar dirt, and industrial, municipal, and agricultural waste discharged into the water. So some of these things might have naturally come to mind when you think of the word pollutant, but others, maybe like heat, might not have. So now that we know what pollutants are, what is a discharge of a pollutant? It's the addition of any pollutant to navigable waters or the ocean from any point source. At the highest level, navigable waters are waters of the United States, including territorial seas, which we commonly call WOTUS. And as I'm sure you know, there have been some changes to this definition recently, and that will be covered by Julia later in the presentation. She'll also be talking about some developments in the definition of point sources, but at its core, point sources are any discernible, confined, and discrete conveyance from which pollutants are or may be discharged. Point sources include things like pipes, ditches, channels, tunnels, concentrated feeding operations, and vessels. Construction stormwater, industrial stormwater, and stormwater from municipal sewer systems also count as point sources. But point sources do not cover agricultural runoff, return flows from irrigated agriculture, and sources not involving a discrete conveyance. This is a pretty large exemption that covers a lot of sources of water pollution in the United States, and most impairments can be traced to these types of sources. So with those basic definitions in mind, we'll move to our first permitting section, the point source permit section that's implemented as the National Pollutant Discharge Elimination System, or NPDES or NPDES program. A NPDES permit gives a facility permission to discharge a specified amount of a pollutant under certain conditions. They also can contain conditions related to sewage sludge that's a byproduct of the wastewater treatment process. To be a permitted discharge, the discharge must either meet all of the applicable requirements of other sections of the Clean Water Act, like water quality standards, which we'll be talking about in a bit, or the permit must contain conditions necessary to ensure the discharges comply with the Clean Water Act. EPA can delegate this authority to states, tribes, and territorial governments. They then perform the permitting, administrative, and enforcement aspects of the NPDES program, and EPA retains oversight authority. Currently, 47 states have at least partial NPDES authority, meaning this program is largely implemented by states, and Julia will be talking a little bit more about this later. Under the NPDES program, there are two types of permits. Individual permits, which as the name suggests, apply to and are specific to the conditions of an individual facility. General permits, on the other hand, have common conditions that are developed for a group of facilities that have similar qualities. So we have a number of general permits in Virginia. An example of two of them would be one for vehicle wash and laundry facilities and another for certain type of industrial stormwater discharges. In order for the state or EPA to develop appropriate permits, facilities must disclose the permits they discharge as part of the application process. If a pollutant isn't disclosed through this process, the facility does not have permission to release it under the permit. With that information in hand, EPA or the states can assess what permit conditions might be needed to make sure the discharge complies with the Clean Water Act. In addition to monitoring requirements, reporting requirements, and setting out specific analytical testing methods, NPDES permits generally can contain technology-based effluent limits and water quality-based effluent limits to control the amount of pollutants in the discharges. In some cases, there are national effluent limitation guidelines for a particular industry. In other cases, permitting agencies must undertake a case-by-case analysis using their best professional judgment to consider appropriate technology for treatment technology for the point source. Technology-based effluent limits are developed independent of the potential impact on a discharge to the receiving water. Those impacts are addressed through water quality-based effluent limits. That means the technology-based effluent limits are about what technology is available to treat the pollutants, and water quality-based effluent limits are put in place if the discharge would violate a state's water quality standards, which we'll be talking about a bit more later. Now Dave is going to talk a little bit about what these permits and requirements look like in practice.
Okay, so we thought it'd be helpful to actually show you a little bit of a permit, just to give you a sense of how these documents actually work, what they do. And here, what you can see, this is a page from a permit for a facility in Pennsylvania that does pharmaceutical manufacturing. And the key thing to note here is that it specifies what the numeric limits are on the amount of pollutants that can be discharged. And it also specifies monitoring requirements. So when you have to grab samples and what you are monitoring for. And so the idea here is that compliance is reduced to some fairly specific terms. Some of them will be qualitative, but a lot of them are quantitative. And if we go to the next slide, this next slide is a discharge monitoring report. And on this discharge monitoring report, on the right, you can see these two columns that I've circled, one that says DMR value, that's the actual measured value, and then the permit limit. And this report, which is submitted by the facility to regulators and which is available to the public, provides very clear documentation of whether the facility is actually in compliance with its limits. Here you can compare the numbers and see that there is complete compliance. And again, this is, I think, very important to an attorney because this helps explain why this is a very readily enforceable system. When environmental laws or any kind of law is very vague or sets very qualitative standards, it can sometimes be hard to judge who is in compliance and who is not. But where you have a requirement to monitor and you have a requirement to report actual data, and then you have clear standards, then compliance is much easier to measure. And so the Clean Water Act, in particular, the National Pollutant Discharge Elimination System, is I think, an example of selecting very clear, very specific standards that then make it a more enforceable system. All right, back to you, Carol.
Great. Now, something to know about industrial wastewater in this country is not all wastewater is discharged directly to our waters. A lot of industrial users send their wastewater to centralized treatment plants. These are called publicly owned treatment works, or POTWs. This means that industrial users don't have their own NPDES permit because they aren't discharging directly to a water. In this setup, it's the POTW that has the NPDES permit. So the Clean Water Act requires POTWs to regulate their industrial users through something called a pretreatment program to make sure that the pollution coming from the industrial users doesn't cause pass-through or interference with the POTW. Pass-through occurs when an industrial discharge causes the POTW to violate its own NPDES permit, where interference occurs when a discharge disrupts the POTW's operation or its sludge use or disposal, and then results in a violation of the treatment works NPDES permit or other applicable laws. POTWs are required to know what waste they receive from their industrial users, and industrial users have to disclose effluent data to the treatment works. Once sources of pollution are identified, the POTW can implement its own pre-treatment standards for the industrial users. These could be categorical standards that apply to certain industrial processes and limit specific pollution, or they could be local limits that are site-specific and based on the specific needs and concerns of a POTW and its receiving waters. POTWs can also require their industrial users to monitor for certain pollutants and implement best management practices to control the pollution in their wastewater. Like the NPDES program, the pretreatment program is an effort between federal and state environmental agencies and ultimately the POTWs that are regulating their industrial users' discharges. I'm passing it back to you, Dave, for some information about stormwater in this regime.
Okay, good. So when people think about the NPDES program, they often think primarily about industrial facilities and wastewater treatment plants. It also applies to stormwater. And the reason it applies to stormwater is that most urban stormwater moves through some sort of discrete conveyance on its way to being discharged into surface waterways. And so you'll sometimes hear people refer to urban stormwater or stormwater more generally as non-point source pollution. Please don't ever do that after hearing this seminar. That's almost always wrong. Urban stormwater almost always is point source pollution. And it's important to talk about because first, it's very important for water quality, and also because urban stormwater has generated a lot of legal work and consulting work and engineering work in recent years, and is really one of the biggest challenge areas we face with the Clean Water Act. So I'll just briefly explain first why urban stormwater is such a challenging and significant problem, and then explain how the Clean Water Act tries to address it. So the reason urban stormwater is a problem, well, there are a couple of, I'll sort of explain them using this chart here, or this map here. So this is a map of San Francisco. And on this map, you can see a whole bunch of different outfalls marked around the city. You can also, if you're very observant, you'll see numbers on the left-hand side. Those numbers are because this is from a legal complaint, and it's a legal complaint recently filed by the state of California in the United States Department of Justice against the city of San Francisco for alleged violations involving stormwater. And so one reason stormwater is a challenge is because in many older cities, it gets mixed with regular wastewater, and both under normal conditions get routed together to wastewater treatment plants. That works great because stormwater often is dirty, and so getting it treated is a good thing. But when you have heavy storm events, which we are having more and more of, then you can overwhelm the wastewater treatment system and you need an escape valve. And so we have what are called combined sewer overflows that release the whole potent mix of stormwater and wastewater directly into surface waterways. So that's one big problem. But even when we don't have combined systems functioning and stormwater is discharging directly to surface waterways, it's picking up everything that is on city streets. So shavings from brake pads and oil and grease, dog poop, things like that are all getting washed into surface waterways. And it's, in the aggregate, a fairly significant problem. And it's a difficult problem to solve because it's not coming from one discrete point or one discrete source that you can zero in on. Instead, it is typically coming from lots and lots of different properties, different activities, and is happening over a long span of time. So how does the Clean Water Act try to address this? Well, there are two basic permitting programs within the NPDES program that address stormwater. So next slide, please. One response is a set of a permitting system for industrial stormwater. So this is stormwater that comes off of industrial properties. And this gets permitted in two ways. One is through individual permits that are tailored to those specific sites. And the other, and the more common way, is through what are called general permits. And these are standardized permits that apply to large groups of similar activities and that permittees just basically opt into. They say, I am just going to comply with this standardized set of practices and monitoring reporting requirements, and that's going to be my compliance measure. So this theme of individual permitting and general permitting is something that we'll come back to later on when we talk about Section 404. That's an important part of the Clean Water Act. Okay, next slide, please. The other main response is something known as a municipal separate storm sewer system permit, or an MS4. And next slide, please. And an MS4 is not the permit, but the MS4 itself is a publicly owned or operated stormwater drainage system. And in most cities, we have a mix of privately operated stormwater systems, but those typically feed from private properties into a city-run or special district-run publicly operated stormwater system that ultimately discharges. And so that entity, usually the city or some combination of cities or maybe a special district, is the one that actually has the discharge point, and it has to get the permit. And these permits are different from what you might think of as a typical permit. It's not just a simple set of requirements. Instead, next slide, please. Instead, it's really more of a regulatory program that the city has to implement. And here you can see what the different elements of that program are. And so when a city gets a municipal separate stormwater sewer, an MS4 permit, it is essentially committing to implement this sort of regulatory program to address stormwater within the city. And this is, again, a challenging thing for cities to do because these are not always easy things to regulate. And because cities often also feel like they're somewhat strapped for funding and for resources to implement the regulatory program. So the result is that this is both an area of significant challenges. There are often debates about how strong these permits need to be. And it also continues to be a major, or urban stormwater continues to be a major source of water quality impairment. And again, an area where there are a lot of cutting edge issues that attorneys are working on. So Carol, back to you.
Great, thanks. I thought I would talk a little bit about one area I spend a lot of time working in, which is how the NPDES permit program can be used to control contaminants of emerging concern like PFAS. So some of you may know PFAS, or per and polyfluoroalkyl substances, are a group of over 15,000 chemicals. They've been widely used by industries and in consumer products since the 1940s because of their stain, water, or oil resistant qualities. They can be found in things like waterproof clothing, food takeout boxes, carpet and upholstery, and firefighting foam. PFAS are known to cause serious health impacts to people and animals, and unfortunately, they also have been shown to disproportionately harm people of color and people living below the poverty line. They're often called forever chemicals because they don't dissipate, dissolve, or degrade, but instead build up in the environment and in our bodies. So this is a picture that we've created of the PFAS cycle, which just shows, it's everywhere, cycling through our environment, but I'm going to be focusing on where these two red circles are. So one of the biggest examples that we've been dealing with in the South is the Chemours plant on the Cape Fear River in North Carolina. So Gen X, which is a type of PFAS, came from this plant and contaminated the drinking water for about 300,000 people downstream in Wilmington, North Carolina. Gen X levels were found to be as high as 39,000 parts per trillion at the facility's outfall to the Cape Fear River. And for context, the new drinking water standards for this chemical is 10 parts per trillion. The NPDES permit program could be a powerful tool to learn more about PFAS discharges and to control them. Since the definition of pollutant is so broad, states should be requiring disclosure of PFAS discharges through the NPDES permit program so they can think about ways to stop this pollution at one of its most significant sources, which is concentrated streams coming from industrial facilities into our waterways. So up next, we have Section 404 of the Clean Water Act. This section governs the discharge of dredge or fill material into navigable waters. A Section 404 permit would be required for things like filling wetlands or streams when building a house or commercial development, a highway or pipeline, or a mining project. The Section 404 permit program is implemented by the Army Corps of Engineers. And like the NPDES program, Section 404 permit authority can also be assumed by states. And also like the NPDES permit program, there are both individual and general permits under Section 404. And Dave will be talking a bit more about these in a second, but the general permits can have national coverage, meaning they're applicable to specific categories of projects nationwide. An example of this would be there's a Section 404 nationwide permit for linear transportation projects, so things like roads, when they impact less than half of an acre of non-tidal waters or less than a third of an acre of tidal waters. And I think, first I'm going to run through the Section 404 guidelines, and then I'll pass it off to you, Dave. The Corps follows the Section 404 B1 guidelines in reviewing permits. Ultimately, the Corps cannot permit the discharge of dredge or fill if there is a practicable alternative to the proposed discharge, which would have less adverse impact on the aquatic ecosystem, so long as the alternative does not have other significant environmental consequences. So as you've probably already realized from this presentation, environmental lawyers love acronyms. So we have boiled this down to mean that a Section 404 permit may only be granted for the least damaging practicable alternative, or LEDPA. In this context, determination of whether an alternative is practicable includes consideration of costs, existing technology, and logistics. And for non-water dependent projects, practicable alternatives that don't impact waters are assumed to be available. So something like a housing development would be a non-water dependent project, whereas something like a marina would be a water dependent project. The Corps also cannot grant a Section 404 permit if a project is found to be contrary to the public interest. The Corps weighs numerous factors in making this determination, including potential direct, indirect, and cumulative impacts of the proposed project on historic and cultural resources, wetlands, floodplains and flood hazards, fish and wildlife habitat, economics, water quality, and general welfare. Now, Dave, I'll hand it off to you for some more details.
Okay, so first off, I'll say there are a lot of questions that have been piling up in the chat. Some of them I've been trying to get to if it's simple and a quick answer. Some of them we will get to later in the presentation. But if we don't get to it right away, we have seen it and we'll try to respond to as many of them as we can later on. So please keep those questions coming. And thank you to those of you who've already posted questions. Okay, so I'm going to give you a little bit of the practical realities of Section 404 permitting. And let me start by saying why I think this is important. And the basic reason is to put it bluntly, there's been a lot of mythology built up around Section 404 of the Clean Water Act in particular. And I think a fair amount of that mythology has been built up by the United States Supreme Court, which is in the habit of writing decisions that I think are at best incomplete and at worst pretty inaccurate in their descriptions of how this program works. And it conveyed the impression that the 404 program is incredibly far-reaching and also incredibly burdensome. And so here I've got some basic statistics or basic description of the different types of compliance methods for Section 404. And you can see here that, as Carol said, you can get an individual permit for a project that is higher impact and for which you want or need to get a bespoke permit that is designed for that particular project. And the Army Corps stats show that you're running well up into the tens of thousands of dollars or potentially higher to get that sort of permit. And typically it takes about 264 days from the receipt of a complete application. And of course, you have to take time as well to prepare that application. So this is not a trivial process to go through. But there's an alternative, which is to get a general permit. And general permits apply to projects that have much lower impacts and, again, are highly standardized. So essentially, you just opt into a preset group of permit conditions. And as you can see from the statistics here, those are typically much cheaper and much faster. And then, of course, there's a third alternative, which is that if you can find a way to reconfigure your project so that you don't fill waters of the United States, then you don't need a permit at all. And so one of the questions the Army Corps will ask when a permit application comes in is, do you really need to build in a way that involves filling? Because if the answer is no, then you can avoid the process entirely. And Carol, next slide, please. One other thing before I get into some statistics on how often, or some numbers on how often these different types of compliance processes occur, one other thing to be aware of with Section 404 is that in addition to being a key Clean Water Act requirement, it also is often a trigger for other environmental laws. So both the National Environmental Policy Act, which requires review of federal agency actions with potentially significant environmental impacts before those actions take place, and then also Section 7 of the Endangered Species Act, which is one of the most important parts of that statute. Both of these are often triggered by discretionary decisions under Section 404 of the Clean Water Act. Okay, next slide, please. So here's some of the realities of Section 404 permitting. Multiple studies have looked at which type of permitting process people use, and between general permits and specific permits, leaving aside the projects that don't need permits at all, about 97% of the projects get general permits. You might also think from Carol's description and from other descriptions you've heard of how the process works, that it sounds really stringent. You might think permit denials happen all the time. They don't. Multiple studies that have looked at how often permit denials occur, and this includes some, I've cited somebody else's work here, but this also includes some work that I've done, have found that it's very, very rare for a permit denial to actually occur. Instead, what most often happens is the project gets approved, though perhaps with some strings attached. And next slide, please. And importantly, one of the strings that can be attached, not always, but sometimes, is a requirement for what's called compensatory mitigation. And compensatory mitigation in general terms just means compensating for an otherwise forbidden environmental impact in one place by providing some sort of extra environmental benefit in some other location. And so with Section 404 permitting, the way that this typically works is that the applicant to fill streams or wetlands pays for the restoration, or in some cases the creation, although that doesn't work very well, and in some cases the protection, but usually the restoration of damaged streams or wetlands in some other place. And at its best, the idea is that you get development in places where you want development, you get restored environmental conditions in other locations. So again, this is a key element of a lot of Section 404 permitting. And Carol, back to you.
Great. I was just going to highlight a project I worked on a couple years ago that involved a Section 404 permit, but a lot of the things that Dave just talked about came into play as well. So thinking about the public interest requirement, NEPA review, and then also Section 106 of the National Historic Preservation Act, those all can come into play as part of the Section 404 permit process. So that means it can be a really useful avenue for communities to elevate concerns they have with a project that impacts waters. So a couple of years ago, a drinking water withdrawal and associated pipeline was planned to be sited at Rassawak. Rassawak is the historic capital of the Monacan Indian Nation in Virginia. It's at the confluence of the James and the Rivanna rivers, and a municipal water authority plans to pipe water from the James River to another part of the county. The tribe was concerned about impacts the project might have on burial sites on the property, as well as other important cultural heritage resources. Since the project would impact the James River and a number of other streams with its pipeline component, it required a Section 404 permit. The permitting process gave the tribe a venue to raise and discuss its concerns with the project applicant, and ultimately they reached an agreement that moved the project just upstream to another site that would have less of an impact on the core portion of Rassawack. So now we are going to take a step back and talk about water quality standards. There are two general approaches that the Clean Water Act uses to regulate water quality. We talked a little bit about these in the NPDES section. So we have technology-based standards, which operate by identifying regulated pollutants, identifying regulated activities or industrial sectors, setting effluent standards at technologically feasible levels, implementing and enforcing standards, and revising standards as technology evolves. This can be done at a national level and also at a case-by-case level. Then we have water quality-based regulation, which operates by identifying desired environmental conditions for waterways, developing water quality standards protective of those desired conditions, and developing pollution control approaches that will or are supposed to attain compliance with those water quality standards. So I'm going to run through the general broad overview of this part of the Clean Water Act, and then Dave is going to go into a little bit more detail. So Section 303 of the Clean Water Act requires states to identify water quality standards for all waters within its jurisdiction. That means first, states, territories, and authorized tribes are required to establish a designated use for each of its water bodies, and these are things like fishing, swimming, drinking water, agriculture, industry. Then they adopt water quality criteria to protect the designated use. These criteria can be numeric, the maximum pollutant concentration permitted in the water body, or they can be narrative. So that's criteria that describes the desired condition, something like free from visible oil film. If the water meets its designated use, anti-degradation policies and plans are put into place to ensure that water quality is maintained. If a water is identified as impaired or threatened, a total maximum daily load, or TMDL, has to be developed for the water. This is the maximum amount of a pollutant that can be present in the water body and still meet the water quality standards. TMDLs are developed by looking at the point source load, non-point source waste load, natural background levels, and then an additional margin of safety. After the TMDL is calculated, states allocate the load among various sources to the water. States are required to update and resubmit their impaired waters list every 2 years, and all should be working in pursuit of having unimpaired waters. So Dave, passing it over to you now.
Okay, so I'm going to talk a little bit more specifically about the elements of water quality standards. I'll give you a couple of examples and then a little bit more about how they actually get implemented. That's also a subject we'll come back to during Julia's talk. So as Carol said, there are three basic elements of a system of water quality standards. The designated uses, so these are the uses to which a state wants to put the waterway. Criteria, and so these are standards designed to assess whether the water is of sufficient quality to support those designated uses. And then behind all of this, or underlying all of this, a non-degradation policy that is designed to ensure that water quality standards keep moving states toward the underlying goals of a fishable and swimmable set of waterways. So next slide, please. So here you can see an example of designated uses. This is from the Water Quality Control Plan for the San Francisco Bay. And you can see here that it's a narrative description of the one particular type of use that would be made here, particularly of streams feeding into the bay, of providing sufficiently cold water for things like salmon and steelhead trout. Next slide, please. And then here you can see an example of water quality criteria. And these criteria can be narrative, they can be numeric. This particular example is numeric, and it's showing, again, a level of acceptable pollutants within the water And if the water quality is below that level, then it meets, or excuse me, if the pollutant levels are below that level, then the water meets the water quality standards. Next slide, please. So there, again, are three different primary ways in which water quality standards get turned, or at least we try to turn them into actual improvement of water quality. 401 certifications, 303D lists, TMDLs and continuing planning processes, permitting. And then the last one here is important. If states want to do things beyond these three basic elements with their water quality standards, they can. There's nothing in the Clean Water Act that takes away states' authority to establish more stringent standards or extra programs. Some states, through their own legislation, forbid their administrative agencies from doing that, but that's a state-level restriction, not a federal one. All right, next slide, please. So Julia is going to talk in more depth about 401 certifications. I really just want to include this because the Dos Wallops River, which you're seeing here, is very pretty. And that's the river that was at issue in perhaps the most important Clean Water Act Section 401 case that's been decided, a case called PUD number 1 versus Washington Department of Ecology. I'll say a little bit more about TMDLs, and so that's our next slide. So TMDLs, well, let me start by saying that what you're looking at here is the Garcia River, which is a river in Northern California that was at issue in a case called Pronsolino versus Nastri, which is probably one of the most important cases to address TMDLs. So let me just explain, starting with the next slide, what TMDLs are and then what effects they have. So a TMDL is a written report. It's a document. And the report is basically a diagnosis and a budget. So the diagnosis is an explanation of what is causing impairment in that specific river or stream or lake or other water body. And then the report will also include a daily pollutant budget. In other words, a budget that specifies how much pollutant loading that waterway can accommodate on a daily basis and still meet water quality standards. And then EPA's regulations require that overall budget to be broken down into a waste load allocation for point sources. If there are point sources, there may not be in a particular watershed, and then a load allocation for non-point sources. So again, it's a document that basically creates a pollutant budget. Next slide, please. So it's also, I think, important with TMDLs to understand what they don't do. And the first key thing is that unless the states choose to make them this way, they're not enforceable regulatory documents. They're essentially informational documents that specify what level of loading is allowable, but they don't turn that into specific constraints on specific sources, again, unless the state chooses to have that extra element in its TMDL. Now, Section 303E does require states to have continuing planning processes for addressing water quality impairment, but again, it doesn't specify consequences if the states don't actually implement their plans. And all of this matters because it's, in my view, it's a little bit of it's a poorly constructed part of the Clean Water Act, because it basically requires an elaborate program of TMDL writing and TMDL creation without creating clear mechanisms for actually putting those TMDLs into effect. And there are a lot of places where TMDLs are effectively empty informational documents that people don't do a whole lot with. Next slide, and I think it's back to you, Carol. Oh, no, not yet. So the third way in which water quality standards get implemented is through NPDES permits. And next slide, please. And here, this goes back to a question that came up in the Q&A earlier. Somebody asked, well, are permits written in isolation? In other words, do you pay attention to the other permits being written on a particular water body, or do you take into account those other permits? And the answer is both. When you're determining the appropriate technology-based standard, which is the first step in permit writing, you do not take into account whether there are other sources on that particular waterway. You simply identify the industrial category, look up the standard for different pollutants for that category, and write that into the permit. But Water quality standards can be a ratchet that makes permits more stringent where greater stringency is needed to meet water quality standards. And so when you get to applying water quality standards and writing those into permits, then permit writers are looking at the other sources that are impacting that waterway and asking the question, well, what level of additional control is needed in order to comply with water quality standards? And in the conversations I've had with attorneys who are actively working with NPDES program implementation, what they've often told me is that a lot of their work with permitting winds up being on the water quality-based effluent limitations. That's partly because the technology standards are pretty easy to look up and apply, but it's also because in many waterways, you do need water quality-based effluent limitations in order to attain compliance with water quality standards. And so this winds up being a significant point of discussion and negotiation. Next slide. And now I think it's back to you, Carol. Oh, no, sorry. One more slide. So water quality-based effluent limitations, again, because there's a lot of work on them, they raise a number of different challenges, and there are key questions that come up over and over again. The broader question is how to translate water quality standards into site-specific controls, and NPDES permitting is one way of doing that. There are also questions about how fast you need to attain compliance, what sort of mixing zone can be used. In other words, what area can be basically treated as the small sacrifice zone where you don't have to meet the water quality standards. And then what do you do if a water body doesn't meet these water quality standards? Can you add new dischargers? The legal rules there are somewhat complicated. We won't get into the details now, but just it's, I think, helpful to be aware that these questions are important and do come up. So now back to you, Carol.
Thanks, Dave. As the final part of our blitz through the basics, we are going to talk briefly about a couple of the enforcement sections under the Clean Water Act. And first up, we have Section 309. So if the EPA finds someone in violation of a permit, they must notify the violator and the state. This notification is especially important since many states have delegated authority and their own clean water protections. If after 30 days there's no state action on the violation, EPA shall order the violator to comply or bring civil penalties, which can include temporary or permanent injunctive relief. The EPA and state can also bring criminal actions for negligent violations, knowing violations, knowing endangerment, and false statements, and the specifics of all of this is spelled out in the statute. In addition to EPA or state enforcement, the Clean Water Act also allows citizens to bring enforcement suits of their own. Citizens must provide 60 days notice to violators with a letter that specifically identifies the alleged permit violation. And a citizen suit may only be brought if the EPA or state is not prosecuting the violation, and it also must be for a continuing violation, which often means the violation must be continuing at the date of the suit, not just the date of the initial violation letter. So that 60-day window can leave time for the EPA or state to step in and take over enforcement, or for the violator to clean up their act and not be in violation anymore. And with that, Dave, unless you have anything to add, I think we are on to our first question break.
We are indeed on to our first question break. And so there are a lot of questions in the chat already. What I'm going to do just to make sure that we stay on track is set a timer for 10 minutes. Hold on a second here. And then when the 10 minutes are up, we're going to switch over to Julia. There will be more time if we don't get to all of the questions here, but we want to make sure that, so you can ask questions at the end of her presentation as well. So there are a lot of questions in the chat already, and I'm going to pull out, I'm going to start with a basic one. Are water vessels like ships and boats considered to be point sources? Carol, you want to take that one?
Sure. So often ships and boats, at least on my understanding of things, often can discharge things to water when they're expelling wastewater or leaking oil or things like that. So in those cases, they're considered point sources. Dave, is that
That's
line up
my
with your
understanding as
understanding?
well. Yep. All right, this is a harder question. From Scott Hudson. If few 404 permits are denied, has the Section 404 program been effective in restricting dredge and fill damage to streams and wetlands? And then relatedly, do EPA or the Corps provide some stats on effectiveness? Carol, I can take that one, or do you want to start with that one?
I'm happy for you to kick it off. I can add in any additional.
So I would say that this is a question on which there is great debate, and data are getting better, but are somewhat limited. And I think, for years there's been a goal of no net loss of wetlands, but then it's hard to measure how well you're achieving that when you start taking into account things like how functional are the wetlands and not just what the acreage is. With that said, the quick answer that I will give is that I think it is more effective than you might think for a program where permit denials are incredibly rare. And I think there are two reasons for that. One is that the program creates an incentive for people to avoid proposing filling streams or wetlands in the first place. And I think that's a good thing. Like we don't really want, for a variety of reasons, including just vulnerability to flooding, we don't want people building stuff in environmentally sensitive and valuable places that flood over and over and over again. And so those incentives to avoid, I think, are powerful and important. And I think this is true with environmental permitting more generally, often through permitting processes, you may get permission to fill streams and wetlands, but you likely are also to make some adjustments, or you are also likely to make some adjustments to your project to reduce its impacts. And a lot of different adjustments that don't eliminate impact, but at least reduce it, can add up to significant protection. The other thing that I think is very much a subject of debate is how effective compensatory mitigation has been. And if we get a bunch of stream and wetland scientists and mitigation professionals in the room together, the answers to that question will likely degenerate into fistfights. But it's very much an ongoing discussion. Okay, there are a couple questions here about the enforceability. Oh,
Dave,
sorry.
I just wanted to jump in really quick.
Yes.
I do know that CEQ did just produce a report on wetlands after the Sackett decision came down. And it does have some statistics in it as well, although bear in mind, the administration does have a position on Sackett and the impacts of it. So you'll want to read it with that sort of view in mind.
Yeah, there's also some good scientific papers that are, I think, very near to being published that try to quantify the extent of the impact of Sackett in terms of loss protection. But I think that's a little different. The question is, okay, for the wetlands and streams that clearly are jurisdictional, how effective has this program been? And I think the best we can say is it has done a lot, and quantifying it beyond that is hard. So another question, this came from a couple people, but I'm going to read one version of it. Well, let's see. I'm going to summarize it. Is what if a TMDL gets ignored? Like, what are a state's obligations? What can an environmental group or some other group do to try to make sure that something happens with a TMDL if it doesn't seem to be implemented? Carol, you want to talk about that one?
I am not as familiar with that. So Dave, I'd be happy for you to take that one, or okay. Julia.
All right, so this is, I have done some research on after effects of TMDLs, and I think the answer really depends on what the state chooses to do with TMDLs. So I'm in California. The state of California often integrates completed TMDLs into permitting programs, including permitting programs for non-point sources that would not be regulated under the Federal Clean Water Act. So in California, if there is a TMDL, that can create requirements for permitting under the state's water quality law. It can create requirements for permitting under state forestry laws. And those requirements in turn may be enforceable through citizen suits or through other mechanisms. That's not the norm. In a lot of states, if the state basically writes a TMDL and gets EPA approval for it, but is not applying it to non-point sources, then the effect is really minimal, and there's hardly anything other than political activism and seeking some sort of cooperative program or grant funding that people can do. And for a long time, there's not been good data on what the TMDL program actually achieves in terms of water quality improvement. There's a legal scholar named Annie Brett at the University of Florida who has a study that I think is coming out, I think it's soon to be submitted, but what she's told me about the results and what she's tried to do is actually look at watersheds with and without TMDLs and see if she can discern any difference using a big, massive database in water quality outcomes. The quick answer is no difference. And I think that underscores the fact that TMDLs often don't do a whole lot, and it's hard to make them do a whole lot unless the state is willing to have them be effective documents.
Yeah, and this is Julia. I would just weigh in the sense, Dave, you brought it up at the beginning. These are planning documents, essentially, right? They don't always, unless you're in a state like California where they get sort of wrapped into your permit. They're a plan for addressing pollution. Certainly, you would have the opportunities with regards to permit issuance to challenge a permit saying it's not in compliance with the limits established by the TMDL. And the one exception I would point out is the Chesapeake Bay, right? That is the one time or so far that EPA has come in and said to the states in the Chesapeake Bay region, you guys aren't implementing a TMDL essentially for the Chesapeake Bay. We're now going to provide oversight and work with you to issue the TMDL and see it through to implementation. That's the one model sort of out there. And, there's differences of opinions of how well the Chesapeake Bay TMDL is achieving its goals. So,
yeah, and there are other examples of TMDLs that I think have been pretty powerful. So I showed you the Garcia River, a slide of that. The after story of the Garcia River and that litigation is really a positive one for significant improvements in water quality driven in part by a TMDL. Another example is Lake Champlain in Vermont and New York. And then there's also a comment in the Q&A from Ashley Wendt, who's from a state DEQ, said, basically reminding us of the importance of acknowledging that the waste load allocation portion of a TMDL, in other words, the portion that then feeds into water quality-based effluent limits, that part is more readily enforceable. And that part has more of a direct regulatory hook. I think the issue is that so many people looked at TMDLs as the great hope for addressing non-point source pollution. And there they have not, the evidence is that with some prominent exceptions, they really have not done nearly as much.
and I would just add, I know we don't want to talk about TMDLs the whole time, but there has been a movement, I'd say in the last 5 to 10 years, the states refer to it as the TMDL vision document, where it's a little less focus on developing the TMDL plan itself and moving more towards focusing on actual approaches to address the non-point solution or pollution that's been identified or by a state. The idea is you don't spend all your time planning, you get to just start getting at the pollution right away. Because these are big, heavy lifts in some cases, right? They take time and resources to sort of put together. They're good planning documents, no doubt, but sometimes the state just wants to get at it. So.
Okay, so we are at 10 minutes. So I'm going to hand the mic and we'll hand control of the slide deck to Julia, who's going to talk. And then there will be another Q&A period once Julia is done. So please keep those questions coming, and apologies if we haven't gotten to yours yet.
Okay, I'm just waiting to get control of the slides. Let's see, there we go. So I'm going to take a step back and talk a little bit. As Dave pointed out, I work for an organization that represents the 50 state water quality programs, plus Washington, D.C., as well as 6 interstate compact that exist out there. They were created by Congress. The one here in the DC region is the Potomac River Basin Commission. We have the Ohio River Basin Commission as well. They sort of stop at the Ohio. But those are collections of states sort of working together on particular issues that are impacting their regions. I want to focus a bit of the discussion on, I'm having a little trouble advancing slides. There we go. Okay. Focus on the relationship between our federal partners at the Environmental Protection Agency and the state partners who, as Carol pointed out, in 47 states are the permit writers for NPDES permits. They are the ones who are actually taking the time to develop TMDLs, to establish water quality criteria or designated uses. They're really, one way to think about it is sort of EPA's agents on the ground implementing the Federal Clean Water Act. Cooperative federalism, to my mind, is infused in all of the major environmental statutes. EPA, to a certain extent, sets the sort of floor, and states can come in and, well, they must meet that minimum, but they could go above and beyond if they so choose. Again, whoops, sorry, my slides are going crazy. With cooperative federalism, it's really the balancing between federal and state interests. And most of the time, the interests are aligned fairly well, but sometimes they get a little out of balance depending on the goals or focus of particular administrations. I will say in my job, I spend a lot of time talking about cooperative federalism. You see cooperative federalism in a few places in the Act. So in particular, Section 101 of the Clean Water Act, I think Carol had that on one of her slides, and talking about Congress recognized from the very beginning that states played a key role in the Clean Water Act. As I said, 47 states write NPDES permits in their states. The 3 states that do not have delegation under Section 402 of the Clean Water Act are New Mexico, New Hampshire, and Massachusetts. At any point, any one of those 3 could come in and say, hey, we want to control our destiny and run our own NPDES programs and apply to EPA to do that. This is a little bit of a distinction between another section in the Clean Water Act, which I'll get to, Section 401, which was a direct grant of authority from Congress to the states, recognizing the important role that states play in our federal system of government. And sort of finally, the last place where you see a lot of federalism language, and that a group like mine tends to point to when we're working with our federal agencies, is an old executive order 12132. It was issued during the Clinton administration, but it has never been repealed. It is still on the books, and it sets forth specific federalism consultation requirements for federal agencies. I will say there aren't many people currently working at EPA that know about this executive order. It's usually a little bit of a surprise when we come in and talk about it. But it is really a key document that sort of sets forth the expectations of the administration with regard to how states will be engaged with federal partners as regulatory changes or policies are being made. So the first real issue that I want to get into and spend some time with you all is the waters of the United States issue. If you've spent any time in water law, Clean Water Act law, Drinking Water Act, Safe Drinking Water Act, whatever it is, you've probably heard about WOTUS, or Waters of the United States. WOTUS is a fundamental term in the Clean Water Act that defines the geographic scope of federal jurisdiction under the Clean Water Act. And this is a really important distinction. This is all about how far the federal authority extends with regard to the Clean Water Act. It does not impact state clean water laws at all. And all 50 states have their own version of a Clean Water Act in some fashion. So there's messaging out there oftentimes with regard to WOTUS that if our EPA partners can't define WOTUS, or we don't end up with a durable definition, that our waters out there in the US will not be protected. That's not the case. States will be protecting in some way. We can argue about how well they're protecting or all of that at another time. So determining whether you have waters of the United States is essential before you can establish a water quality standard or a total maximum daily load or issue an NPDES permit or Section 404 permits under the Dredge and Fill program. The Clean Water Act talks about waters of the United States as navigable waters, and that's defined in the statute as waters of the United States, including the territorial seas. We've got a really circular definition going on here. And you'll see that this is one of the key issues that courts have talked about. Congress, you need to come in and actually define what waters of the United States means. So this has been a long and winding road. I have been sort of here in DC since 2005, and this was one of the first issues I got to work on then. I do truly believe, with 15 years left in my career, that I will be talking about WOTUS and waters of the United States for the remainder of my career. It has been a long and winding road of Supreme Court decisions that have laid down markers along the way. And I will quickly go over some of the key cases. You've probably heard about many of these. Again, if you've spent any time in this world, these are cases you've probably heard about. But in 85, we start with the Riverside Bayview case. And in this case, it was a unanimous Supreme Court decision that affirmed an Army Corps and EPA regulations defining adjacent wetlands as WOTUS. The court observed the functional role of adjacent wetlands in the broader aquatic ecosystem, while explicitly not addressing the jurisdictional question of isolated wetlands. The court also indicated that the word navigable in the act was of limited effect. Then we come to 2001 and what most people refer to as SWANC, or the Solid Waste Agency of Northern Cook County, the Army Corps of Engineers. This is what lots of us talk about as the migratory bird case. So again, we make it to the Supreme Court, and the Supreme Court indicates that isolated intrastate non-navigable waters cannot be considered a WOTUS based solely on the presence of migratory birds. So we all know that wetlands are a really sort of key waypoint for birds as they're migrating north to south, south to north. And the court in this case did not invalidate the entire definition, but qualified how it can be applied to isolated waters. The court notes that although Riverside said the word navigable was of limited effect, that does not mean it has no effect. So this is the first time we hear a court use the phrase, the court states it was the significant nexus between the wetlands and the navigable waters that informed our reading of the Clean Water Act in Riverside. You're gonna, significant nexus is gonna come back up. So then we move up to 2006, and we have the Rapanos decision. And Rapanos, again, we're at the Supreme Court, and this case, not unanimous, not a 7-2 decision. This one, we get a 4-1-4 split. There is no majority opinion coming out of Rapanos. And Rapanos, the opinion sets forth basically two standards, and you've probably heard these phrases as well. One is the Kennedy significant nexus test, and the other is the Scalia relatively permanent test or standard. Ultimately, in Rapanos, the court, the plurality said the relatively permanent standard, and I'm sorry, they essentially said both of them apply, which means in practice we ended up with a case-by-case analysis out there. But it did not invalidate the existing regulatory definition of WOTUS. And again, it went to how it's applied. So now we come to 2023, we're getting to present day. First case of the 2023 term is Sackett v. EPA. Again, we're talking about WOTUS. And the Supreme Court in May of this year, or May of 2023, invalidated the significant nexus standard and held that the relatively permanent standard from the plurality opinion in Rapanos was the appropriate analysis to determine if a wetland or another water is a WOTUS. So it dramatically shrunk sort of the reach of federal jurisdiction with regard to Clean Water Act and the waters of the United States definition. At each of these case points where the Supreme Court has sort of held forth on a particular issue, as I think many of you probably know, EPA and the Army Corps of Engineers then had to come in and interpret the Supreme Court opinion. So after 1985, the EPA and the Corps issue regulations defining a WOTUS. In 2015, those definitions are amended and we get the new Clean Water Rule. And actually, before I go into the Clean Water Rule, let me tell you about sort of the highlights of the 1986 regulations. So a water of the United States were all waters which were used or could be used in interstate or foreign commerce, including all waters subject to the ebb and flow of the tide. All interstate waters, including interstate wetlands. All other waters such as lakes, rivers, streams, but including intermittent streams, mudflats, sandflats, wetlands, etc., which are or could be used by interstate travelers for recreational or other purposes, or from which fish or shellfish could be taken, which could be used for industrial purposes by industries and interstate commerce, and all impoundments of waters otherwise defined as waters of the United States under this definition. It also included tributaries of waters, territorial seas, those sorts of things. So 2015 then, this is after the Rapanos decision. EPA and the Corps try again to issue clearly define a definition of waters of the United States. And this definition was all waters used in the past, present, or future in interstate or foreign commerce, or subject to the ebb and flow of the tide. All interstate waters, including interstate wetlands, territorial seas. All impoundments of waters otherwise defined as WOTUS. All tributaries. All adjacent waters as defined in the herein, and all waters determined on a case-by-case basis to have a significant nexus to a traditional navigable water or interstate water. So here is where you're seeing the federal agency try to wrap in the plurality opinion of Rapanos and Justice Kennedy's test. A lot of controversy after the 2015 rule. We also had an election in there and a change of administrations. And the next administration made it a priority to look and conduct a regulatory review. And under that review, the EPA determined that they needed to look at a new WOTUS regulation. So in 2019, they recodified the pre-existing definitions of WOTUS, so pre-2015. And we went back to what many of us who've been working in this area for a while refer to as the 2008 Rapanos guidance. So this was an interim step before 2015, but after the Rapanos decision was held by the Supreme Court, EPA and the Army Corps of Engineers issued a guidance trying to explain how they would be treating waters of the United States. Many of the stakeholders in this sector looked at that and determined it really wasn't appropriately done in guidance, right? It had the force and effect of law, so it really should have gone through the regular notice and comment process, which is a whole other area of administrative law. I'm sure we could spend a lot of time talking about. But anyways, we come to 2019 and the Trump administration, and they repealed the 2015 Clean Water Rule. And they go back to the 2008 guidance. Then in 2020, they issue what is called the Navigable Waters Protection Rule. And this is a new rule that basically pulls back from the Clean Water Rule and defines WOTUS as including territorial seas and traditional navigable waters, perennial and intermittent tributaries, as defined, lakes, ponds, and impoundments contributing surface flow to a traditional navigable water. And when we talk about traditional navigable waters, think about the Mississippi or something like that, Hudson River. We're talking, big water bodies, or anywhere you can float a boat. Anyways, impoundments contributing surface flow to a traditional navigable water in a typical year and adjacent wetlands as defined. The 2020 rule said interstate waters are categorically not WOTUS. And it included many exclusions for some agricultural practices, waste treatment, ponds, stormwater features, green infrastructure, those sorts of things. The big thing for many of my members, especially those in the West, the Navigable Waters Protection Rule did not or does not view any type of ephemeral water as a WOTUS. So these are streams that, the majority of the year don't have water flowing in them, or if they do have water flowing in them, it's likely effluent flow from the upstream wastewater treatment plant. And that flow is used to keep the critters in the stream, sort of alive. But it can be this was a particular concern for many Western states in terms of the sort of like a regulatory reach of the Clean Water Act. Now getting up to 2023, as you all may know, we had the Sackett decision, right? And shortly thereafter, the narrowing from the Sackett opinion, EPA and the Corps again issued regulations to interpret the Supreme Court opinion. And basically, EPA issued what they're calling a conforming rule. So basically, taking their definition of WOTUS and stripping out any of the text pertaining to the significant nexus standard. It removes interstate wetlands as a category of WOTUS, but keeps interstate waters, whether navigable or not, and amends the definition of adjacent to mean having a continuous surface connection. That was also language that came out of the opinion from Justice Alito. The rule does leave in place the regulation of non-navigable interstate waters, and it purports to define tributaries, relatively permanent and continuous surface connection in the regulations. Litigation, we're in it. We've been in it for a long, long time. And I think we're going to be here for quite some time. Currently, there are challenges by 27 states and many industry groups over the changes to the definition of waters of the United States. Louisiana, oops, sorry. This is a map that EPA has on its WOTUS website. It gets updated every once in a while, but the current state of play for the definition of WOTUS is confusing. There are a set of states that are operating under the 2015 definition of WOTUS and those that are operating under the Navigable Protection Rule definition of WOTUS, depending on the stays that have been issued by some of the courts. Let me just catch up on my notes there for a second. All right. I do believe, let's see. Yes. All right. So there's more to be seen on Sackett and more litigation to come. I can tell you from what I hear from my members, they're not getting a lot of questions or a lot of pushback from entities coming in seeking permits, for instance, on whether something is a WOTUS or not. But we also know that in some cases, getting the Corps to make a determination as to something, what's called a jurisdictional determination. So that's sort of the analysis that is done to help you determine whether or not you need to come in for a 404 permit. The Corps is certainly still taking its time on making some of these decisions. And I would say, I know there was in the chat some questions about 404 and timelines, and Dave brought up NEPA and the Endangered Species Act. There are a lot of issues wrapped up sort of in all of these 404 permits. And typically it's not the 404 permit itself that is really sort of holding up the process. It's the other things that come along with it. So it remains to be seen how this map will change going forward, but I sure would like to stop talking about WOTUS sometime soon, or at least take a little break from it. I know my members would as well. We do have one of the most recent pieces of action with regard to WOTUS is we've had, I think, the first as applied challenge to it was a property owner in North Carolina. He had a sand mine on his property, Mr. White. So in 2023, shortly before the High Court ruled in Sackett, the EPA brought a civil enforcement action against Mr. White, alleging that he had discharged pollutants directly into adjacent wetlands at 3 properties near Elizabeth City, North Carolina, without the appropriate Clean Water Act authorization or 404 permit. White claimed that Sackett limits the Clean Water Act provision governing adjacent wetlands to only those wetlands that are indistinguishable from a water body that itself is considered a WOTUS. And said, EPA, I don't need a 404 permit. The court essentially rejected Mr. White's arguments and agreed with the agency. Mr. White was seeking a preliminary injunction, a nationwide preliminary injunction, I will say, that would have suspended the WOTUS rule for everyone. But the court rejected his motion, saying that he had failed to show a likelihood of success on the merits, and because he didn't demonstrate how the new rule conflicts with Sackett's narrow test for identifying protected wetlands. So according to the court, the relationship between practically indistinguishable and continuous surface connection is clear. For a wetland to be indistinguishable from a water of the United States, it requires the party to first show that the adjacent body of water constitutes a WOTUS, and second, that that wetland has a continuous surface connection. But it does not mean that it has to be so closely aligned that there's no distinction between the two. Let's see. The court also pointed out that Mr. White's going to have an opportunity to talk about this in any enforcement actions that are taken by EPA at the administrative level. Or he could go and seek a formal opinion on a jurisdictional determination from the Army Corps of Engineers to determine what those wetlands on his properties were. So this is the first. I'm sure there will be many. The big one is to see how the state's lawsuits shake out with regard to WOTUS. But for now, we'll close that chapter and we'll move on to sort of states and groundwater, and another really important case from the last few years that potentially is opening up a sort of new area under the Clean Water Act for states to deal with, as well as for others to be looking to. So I think, as Dave pointed out earlier, groundwater is not covered by the Clean Water Act specifically. Groundwater protection is primarily left in the hands of the states. The federal government has not really gotten into that business, other than some discrete areas with regard to permitting underground injection wells, those sorts of things. But in general, groundwater is regulated by the states. Most states have their own definitions of state waters as well, which sweep in groundwater. As you can see here, I talk about how states get at protecting groundwater, right? We've got some of the definitions, we've got specific state water quality laws, implementing the Federal Clean Water Act, and then implementing other environmental statutes. On occasion, some states will look to the Safe Drinking Water Act, the Resource Conservation and Recovery Act, or the Comprehensive Environmental, I'm forgetting all of my acronyms, but CERCLA or Superfund, as a means of getting at groundwater protection through another act. So in 2020, in Maui County, the Hawaii Wildlife Fund sued the local wastewater treatment plant, arguing that they were sending pollutants to the Pacific Ocean, and these pollutants were not permitted by an NPDES permit. So I don't know how many people on the call have been to Maui, but I have been here and have enjoyed the beaches right near here where the discharge points are. So let's see. In the county of Maui, the issue was we had the wastewater treatment plant taking treated effluent from the wastewater treatment plant and injecting it in permitted underground injection control wells. And then from those wells, the effluent was seeping out through the very volcanic and porous soils and ground that they have there, and ultimately making its way to the Pacific Ocean. And I believe the time for travel was 2 months, which is particularly fast when it comes to water moving. But the idea was that the facility should have had an NPDES permit as well as these UIC permits with regard to the effluent coming out of their treatment plant. And I do want to emphasize this was treated effluent. So they were meeting their treatment limits at the front of the end. But anyways, the county was sued. The state originally sort of agreed with the county. They did not think an NPDES permit was needed. The case went up through the district court to the 9th Circuit. And the 9th Circuit ruled that the Clean Water Act does in fact require a permit when pollutants that are fairly traceable from the point source enter a navigable water. So again, fairly traceable is some new legal terminology that we're coming up with. This was a 6-3 decision out of the 9th Circuit, and the majority opinion did include 2 of the conservative justices. After the 9th Circuit, EPA comes in, and let's see, here we go, here we are. So it was in 2018 that the 9th Circuit affirmed and held that liability was proper where pollutants are fairly traceable from the point source, such that the discharge is the functional equivalent of a discharge into a navigable water. And the pollutant levels reaching the navigable water are more than de minimis. So this is sort of our first test, right? Like how would you determine whether or not pollutant traveling through groundwater appropriately needs an NPDES permit or not? The county appealed to the Supreme Court in 2020, and the Supreme Court vacated and remanded the decision. I do know that the state is working on a permit. Not sure quite where in the process they are with that. But after the Supreme Court issued its ruling in 2020, very shortly thereafter, the administration at the time issued a guidance document interpreting the Supreme Court decision. The Supreme Court decision laid out a 7-factor test for determining when a discharge flowing through subsurface groundwater that ultimately reaches a WOTUS. And time and distance are 2 of those factors. The characteristics of the pollutant and how it may change over the time and distance traveled is another one. And then in January of 2021, the last administration issues a guidance, and they added an 8th factor to the 7-factor analysis. And that 8th factor had to do with system design and performance. So again, at least in Maui's case, the system was actually operating as designed, which was take your effluent, put it in your underground injection well, and sort of move on. But, you know, we ultimately know the pollutants did end up reaching the Pacific Ocean. So according to the last administration, they added this factor to respond to some concerns regarding the use of green infrastructure as a means of preventing water pollution. So there was some sense that perhaps this would limit the appeal of green infrastructure as an appropriate sort of treatment technology for non-point pollution. In September of 2021, we have a new administration. And we get a rescinded Trump administration Maui guidance. Shortly thereafter, in November, the Biden administration releases a new Maui guidance for public comment. And this basically is a restatement again of the 7 factors from the Supreme Court holding. And the new guidance asserts that intent is not a factor to consider. That's not something that the Supreme Court laid out. So system design should not be considered. The one other key piece of the 2023 Maui guidance is that right up front, it does talk about the specific role of states with regard to groundwater regulation and protection. They do spend a lot of time in the guidance talking about, you know, just because we've issued this Maui guidance does not get you off the hook from state groundwater requirements or statutes at the state level with regard to groundwater. We, Aqua, know that guidance after receiving public comment and working through them is in some sort of final form and over at the Office of Management and Budget currently as we speak. And again, OMB is undertaking interagency review. They typically have 90 days to complete that process. They can go well past 90 though. So we should expect to see a final Maui guidance. You know, I certainly would say by this fall at the latest. They're, you know, we're in an election year now, and it's going to get harder and harder to sort of for the agencies to kind of push things out the door and get things to a final state. Just in case whatever happens after the elections in November. One of the, I just went through all the regulatory actions. I apologize, I did not advance my slides. But sort of moving on, again, one of the first as applied challenges to the holding from the Supreme Court opinion was a case in Colorado. Stone v. Mountain High Mining. Obviously, this is about a mining company. It's a gold placer mine near Alma, Colorado. The plaintiffs in this case allege that the defendant mining company improperly discharged pollutants without a permit into the middle fork of the South Platte River from 4 settling ponds and a pond for recycled water. The court concluded that the settling pond's discharge of pollutants through groundwater to the middle fork was the functional equivalent of a direct discharge, and as such, the mining company had violated the Clean Water Act because they did not have a permit. The court, as part of its analysis, did not consider the Colorado Division of Reclamation, Mine, and Safety Department did not consider the fact that that department had issued a permit for the mine site but did not require a separate discharge permit. So, the state kind of came in and said, but hey, our mining department, issued a permit for the mining site, and that should sort of cover everything. The court did not agree with that and said, you do in fact need an NPDES permit. I do think this case has been appealed, but I'm not 100% sure, and I did not have time this morning to do some quick searching on it. But again, I think we're going to begin to see more cases addressing the application of this new functional equivalent test. This is a whole sort of new universe of potential areas of permitting for states and for EPA. Certainly makes an awful lot of sense. You don't want to see an industry sort of, have its discharge pipe stop, just 5 feet from the water body and claim that they don't need an NPDES permit. That it's closing what many said could have been a loophole under the act. But as with everything in the Clean Water Act these days, I think you're just going to see a lot more litigation. So moving on to Section 401, or the water quality certification provisions under the Clean Water Act. I wanted to talk about 401 in the sense that, as I pointed out before, this is authority that was granted by Congress directly to the states. They do not have to come to their federal partners and say, hey, please give us delegation to be the NPDES issuer in our state. And here's how we are going to make sure we're meeting all the requirements of the Federal Clean Water Act. Congress set up 401 specifically as a direct grant to states. And so the overarching sort of goal or focus of Section 401 is for states to ensure that any project which they would not otherwise have had a chance to evaluate will be consistent with state standards. So what we're talking about are projects that don't require a state permit. They only require a federal permit. The sort of most obvious example is hydroelectric facilities, hydroelectric dams on rivers. They are, these facilities are issued 50-year licenses from the Federal Energy Regulatory Commission, but they typically don't have to then come to the state for any other state permits. Section 401 gives states an opportunity to review permits or licenses like this to determine whether or not the operation of that facility will impact water quality in their state. So Section 401 basically says that no federal permit or license can be issued that may result in the discharge to waters of the U.S. unless the state or authorized tribes have authorization in some circumstances to be a certifying authority, unless a state or tribe certifies that the discharge is consistent with standards and other water quality goals, or waives the certification. And then the ultimate result is you either get no certification, you get a certification with conditions, or you get a denial, which means no federal permit or license can be issued. If you look back at the legislative history of Section 401, I believe it was Senator Muskie, he was a proponent of this, had a really nice quote that I think sort of sums up what 401 was getting at. This was during the debates. No polluter will be able to hide behind a federal license or permit as an excuse for a violation of water quality standards. No polluter will be able to make major investments in facilities under a federal license or permit without providing assurance that the facility will comply with water quality standards. No state water pollution control agency will be confronted with a fait accompli by an industry that has built a plant without consideration of state water quality requirements. This is really the nuts and bolts of what 401 was intended to do. And again, I'm going to go back one. So the elements, again, are someone's coming in seeking a federal permit or license that will result in a discharge to a WOTUS. And the state has 3 options for responding to that request. They can grant the certification. They can grant the certification with conditions. So this may be something along the lines of, again, We use the example of a hydroelectric plant, and we'll think about it in the Pacific Northwest with your salmon who are trying to, migrate back upstream to spawn and keep the populations going. Hydroelectric plants, their waste water coming out often raises the temperature of the segment of the water that the effluent is being released into. So a condition on a hydroelectric license could be plant trees along the banks of the water so that the water temperature doesn't raise too much for the fish. Those are the kinds of conditions that you might see in a 401 certification. Or at the end of the day, they can deny a certification altogether. I will say, more often than not, states issue or grant 401 certifications with conditions. It is very rare for outright denials. Now, that might be different than what you're hearing sort of out there when the debates around Section 401 are happening. But contrary to some messaging that was out there, Section 401 is not what holds up many of these large infrastructure projects. I would argue it's the other two environmental statutes that Dave brought out a little earlier that slow down the process of NEPA and the Endangered Species Act. Under the 401 provisions, states must act within 1 year of a request coming in. If they don't act within that 1 year or reasonable period of time as it's defined under the regulations, then the certification is granted without any conditions. So more often than not, states don't want to lose that ability to condition a project. If a denial is issued, oftentimes it's because the state has not had the information they need to evaluate the issue. Oh, and goodness, we're not having a lot of time for questions, so I'm going to start running through this. There's a couple of key cases. SD Warren Co. v. Maine Board of Environmental Protection. In 2006, we had the Supreme Court talk about 401 certifications being essential to preserve state authority and to address a broad range of pollution. And this is the very reason why Congress provided the states with the power to enforce any other appropriate requirement of state law. And this particular phrase comes into play a little bit later. As Dave said, PUD number 1 of Jefferson County, the Washington Department of Ecology, is really the seminal sort of case on 401. It's certainly the one that I love to cite all the time. This again was a hydroelectric facility. The state issued a certification that imposed minimum water flow requirements to protect species of salmon and steelheads. The hydroelectric facility argued that the dam project didn't need to adhere to minimum flow standards because the regulatory body responsible for this was the Federal Energy Regulatory Commission, not the Environmental Protection Agency. The court disagreed and ruled 7-2 and concluded that the state's authority to impose minimum flow requirements per its anti-degradation policy is not curtailed by FERC's power to license projects. States have a role to play here. So we've had guidances. I'm really trying to wrap up. With regard, in 1971, EPA promulgated the first 401 regulations. Those were not revised until 2020, and they were a dramatic revision. And it included it really narrowed the view of issues that a state could consider when it was evaluating a certification request to only those issues related to specific provisions in the Clean Water Act. Previously, it was states were relying on the sort of broad language of, any sort of issue. 2023, the new administration issues another rule, the Water Quality Certification Improvement Rule. And guess what? Lawsuits were filed. So we're sort of waiting to see how those cases may shake out. Louisiana is leading the charge on this. There are close to, I think, 15 states that have signed on to this and said that the 2020 3 rule impermissibly expands certifying agencies' authority under the Clean Water Act. I believe they just filed some briefs or motions. In that case, we still don't have an answer yet. And we will have to see sort of how it plays out. I think just could be another one that the Supreme Court really wants to sink its teeth into, but we'll have to see. And with that, I'll stop, and so sorry that took a long time.
All right, folks. Thanks to all who've stayed with us, and we have just a couple minutes left. And so if you have any more questions, please drop them into the chat. I've been trying to answer some of the questions as we go as well. But I'm going to go back initially to an earlier question. Hold on, if I can, it's going to take me just a second here to find it. Oh, weird. Okay, it seems to have dropped out.
Is it under the answer tab? Did you answer something?
No, this was one that I did not answer. All right, so I'm not finding the one that I had flagged that I wanted to go back to. So let's see. Well, let's start with a quick one, an easy one from Amy Hansen. This is, Julia, what was the name of the Clinton era executive order? The number of the Clinton era executive order that you mentioned?
121. Let me get back to it. There we go. Executive Order 12132.
Okay. So I'm going to throw in one of the other questions that I had flagged earlier that I'm not, maybe that the person who asked it has dropped out, but it was just a question for Carol about clarifying what the obligations for pretreatment are. Like what do you have to do typically with pretreatment, and why do you have to pretreat for stuff that is going to a wastewater treatment plant?
Yeah, so the way I kind of think about it is a quasi delegation of authority to these pretreatment POTWs. So they are taking kind of the tools that would be available under the Clean Water Act and going upstream to the sources that are coming to the wastewater treatment facilities. And it's important that they kind of know what's coming into their facilities and have the ability to control it, because different types of waste can interact with each other. It could be solid waste, liquid waste. Like there's just a lot of factors to account for in terms of how you're ultimately treating wastewater. So it's really important that they know what's coming in. And in some cases, they may require pre-treatment by these industrial users before they send still dirty, but maybe slightly less dirty wastewater to these centralized treatment facilities. And I think another important component is if these waste streams were to change, they need to know so they can make sure they are complying with their own permit conditions. So you might see something like the wastewater treatment plant has its own effluent limits that it has to meet. And then in order to meet those, they've designed their treatment process to meet those. And if an industrial user were to change the type of waste they were sending to the treatment facility, that could potentially affect the POTW's ability to meet its own limits. So it's kind of moving control of the source up the chain. Even though the POTW is the direct source to the water, the waste is coming from a different source. So kind of stretching to the whole food chain there.
And there's also the fear that the waste can just wipe out the treatment plant. Lots of times these are bugs, like microbes, and you can just take the whole treatment plant down. Some of this coming out of industrial facilities.
So I'm going to come back to one other question that's earlier in the chat, and I think I'll start with a response to this, and Carol and Julia, you can chime in if you want. Specifically, the question was about Imperial Beach, which is a city on the border with Mexico on the Southern California coast, and it's heavily impacted by pollution, a lot of which is coming across the border from Mexico. And the question was, well, what does the Clean Water Act do about that? Like, are there remedies for this sort of cross-border pollution? And I think you can take the question and frame it more broadly. Where we have pollution that's moving across international boundaries, what mechanisms does the Clean Water Act provide? I had a student who did a paper on this specific issue with Imperial Beach a couple of years ago, and the deeper she dug, the more frustrated she got with just how hard it was to find a mechanism. And of course, the reason is straightforward. We can't just go apply our laws to Mexico. And so the quick answer is, for pollution that comes across borders, it's very difficult to go to the source, or impossible unless you negotiate some sort of arrangement, or you provide funding, or you do something else like that to go across the boundary and address the pollutants. We have better mechanisms for interstate pollutants, and part of the reason the Clean Water Act was created is to protect states from other states. But international pollution like that is a really tough nut to crack.
I would just say, I agree. I know that there's certainly been the treaties that have been established with Mexico and Canada with regard to it, but the act itself does not have a great mechanism for dealing with it.
All right, we are at just about 11 o'clock. So again, I really want to thank our speakers, Carol and Julia, for doing a wonderful job. Thank ELI for organizing and hosting this event. Sarah for doing so much behind the scenes work to make this possible. Thank everybody for showing up. It's wonderful to have such a big crowd. And I hope that in addition to learning about the Clean Water Act, you've also learned a little bit or seen a little bit about how excited those of us who work on water quality issues and with water more generally are about it. This is a fascinating area of law. And for those of you who are early stages of your career or still in school and are thinking about where you want to go, I think this is a wonderful area in which to practice, and I would encourage you to pursue it.
And I would just say, I'm happy if anyone has any questions after the fact, feel free to reach out. Happy to answer them.
Thank you
All right,
all so
take care,
much.
everybody.
Couldn't have put it better myself, Dave. Remember to check out the rest of our summer school lineup through the end of July. And if you couldn't attend the full webinar today, you'll be able to watch the recording on the event webpage within a few business days. Thank you to Carol, Julia, and Dave for all of your time, energy, and knowledge, and everything you shared with us over the last 2 hours. And I'll see so many of you guys back here in July. Thank you all.
Thank you.